Hello and welcome to this series of talks on the public access scheme for instructing barristers directly in the context of appeals. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. I think the first thing that's important to sort out in your own mind if you're a litigant in person who is thinking of bringing an appeal is what is the court's mindset when it's considering appeals. What does it think it's doing? It thinks it's regulating justice, expediting the provision of justice, but it also thinks that it's moderating costs. So in other words, it's dealing with appeals in proportionate ways, proportionate to the grounds of the complaint and the subject matter in dispute. So in other words, when you're considering whether or not to appeal, you need to ask yourself the question of whether you're bringing a sledgehammer to crack a nut. It's also important to remember that they're applying a regime which has generated case law authority only since about the year 2000. And that means if you're looking at some of the case law before then, it doesn't necessarily give you a good guide to the meaning of the procedural rules that you're dealing with. It's also refining practice on a continual basis. In particular, since the 1st of October 2012, there have been new practice directions on appeals. You can find these in practice directions to part 52 of the civil procedure rules. So that's PD 52A through to E. And it's important to remember that practice directions won't necessarily tell you what the legal meaning of the rules is. They're guidance on matters of practice, but if they contain statements of law which are wrong, then they carry no authority at all. In the context of all this, it's important to see what the court is doing in terms of the case law, and one valuable source, which is free, is the Bailey website. And there you can find the case law of the England and Wales Court of Appeal. Sometimes it can look a bit confusing as to where your appeal needs to go. By the time you've got this far in proceedings and you're trying to work out whether or not you should appeal, you'll probably be able to work your way through this table. So you can see that there are appeals from the county court and from the high court, different levels of judge deciding the original claim, so who are you appealing from, the nature of the claim. A Part 7 claim will be one where there's contention on the facts. A Part 8 claim is going to be one where there wasn't contention on the facts and there was a question of interpretation, for example. You also need to work out whether what you're appealing from is an interim or final decision. And that leads you to the final column, which is the destination of your appeal. So I suggest now you use the pause button and have a look at where you think your appeal is coming from, and that will help you to work out where it's going. But we're going to unpack some of the concepts that are involved, in particular final and interim judgments, in a moment. So a final decision is a decision of the court that would finally determine, subject to any possible appeal or detailed assessment of costs, the entire proceedings, whichever way the court decided the issue before it. Case management decisions, interim relief decisions, summary judgment or striking out are not final decisions for these purposes. Suppose you have a split trial and the question of liability is determined, and then at a later date the question of remedy is to be determined. The liability decision in that kind of split trial situation is considered to be a final decision. Suppose judgment's given for a defendant who's made a submission that there is no case to answer. That's considered to be a final judgment as well. Thinking about appeals more generally in the civil courts, what you'll need to do and have consists of the following. You'll need to have the order of the court or tribunal from which you're appealing. You'll need to find out the time limit for appealing to the Court of Appeal or Appellate Court. If possible, you should have the judgment, but don't wait to get the judgment before you appeal. As we'll see, you appeal from the order rather than the judgment. You need to think about obtaining permission to appeal either from the lower court or tribunal or from the Court of Appeal or Appellate Court. I can't emphasize too strongly that you should obtain advice and make sure you can access the resources you need. As well as having some idea of what you say the law is going to be, and you probably will have that from the decision from which you're appealing, you can see on the screen now two sources of information which are essential if you're going to be trying to run an appeal, particularly if you're going to be doing the things that a solicitor would normally do so that you can instruct a barrister using the public access scheme. So the first important website to know about is the justice.gov website. You can find the civil procedure rules, and I've put up on the slide the link to the civil procedure rules which govern appeals. That's part 52. But also you need to be aware of the practice directions, and these are very often much more easy to understand than the rules themselves. You need to be able to have a look at those, and you can see the second link that is up there is a link to the practice directions relating to part 52. Earlier I was talking about the destinations for your appeal, and it may well be that you felt that that was quite confusing, that there are a number of different places that your appeal can go. In practice, this shouldn't cause too much of a difficulty for you if you ask the lower court for permission to appeal. Because if you do that, quite apart from all the advantages it gives you, the judge might agree that there's a point fit for appeal and be prepared to grant it there and then. There's no harm in asking, because you also get a chance to ask the appeal court, so you get two bites of the cherry. But in addition to all that, if you ask the lower court for permission, the judge is under an obligation to state all the elements essentially that you need to work out where your appeal needs to go. In fact, he or she should tell you where the appeal should go. So first of all, the judge should say whether the judgment or order is final. Secondly, whether an appeal is possible, and if so, to which court. Third, whether or not they're giving permission to appeal, and if not, then the appropriate appeal court to which any further application can be made. And the point is that the civil procedure rules require all these points to be stated in the order which the court draws up following the hearing. Now, if you're listening to this before judgment is delivered, it may well be worth your while to remind the judge about this need, or to ask them for these points, because quite often the judges forget to give you this information. So there's no harm in reminding the judge. So I talked about the practice directions that are relevant. There's practice direction 52A, which is general for all appeals, and you should certainly look at that. But if you're looking at an appeal from the High Court or County Court, have a look at 52B, and I put the link up on the screen, and 52C. I'm not going to talk about statutory appeals and the ones which are subject to special provisions, but Practice Direction 52D is the one you need to look at for those. And then finally, if you've got an appeal which is said to be by way of case stated, have a look at 52E, and also have a look at the justice.gov UK website and follow the links I gave you earlier, and you'll find those.